Good afternoon. I think that our esteemed organizer have asked me to get us started. And given the limited time that we have before you have a moment to catch some dinner, I'll do my best, of course, to introduce our panelists. Of course, this afternoon session, we're talking about the fundamental rights and the future of workplace law. And I'm going to introduce, of course, our three panelists in the context in which they would present. Diane MacDonald, of course, has been practicing law since 1995, first as in private practice, and then, of course, for the BC Teachers Federation. And she's currently, of course, General Counsel for the BCTF. Good friends of mine, they're affiliate of the Congress. And I'm not going to read all of her bio, but basically, say Diane, of course, a background, Simon Fraser University, Dalhousie, of course, School of Law, and of course, a PhD from the Northeastern University. And of course, I'll give her a chance in a minute to, of course, do her presentation. Benjamin Oliphant, of course, is practicing public law litigation and labor and employment groups at the company he's with right now is Gall, Legge, and Grant Zwack. And of course, he of course is on constitutional, administrative, and law matters that has appeared as counsel before the BC Supreme Court, the BC Court of Appeal, and the Supreme Court of Canada. And prior, of course, to his current employment, he's a graduate of and been honors at the University of Toronto, Faculty of Law, and there's more on his bio, but the last 2 points I will make, he's also recently co-author a chapter on the Charter and Collective Bargaining with David Dorey, and the law work in industrial relationship and collective bargaining, Toronto, Edmund, 2017, and it's acted as, of course, an adjunct professor of law at the UBC, teaching a course on labor law on the Charter. Christopher of Pigott, of course, is also our last presenter today on this panel. He's a partner, of course, in Toronto office of Fasken and Martineau. And Christopher, I was just saying to him, 3 cases that he was involved with the Supreme Court, I was intimately engaged in because we were intervener in all 3 of these cases. And of course, both will be presenting today, of course, on the subject of our afternoon talk. So, without further ado, I will give the time to our presenters and try to hold them to account for 15 minutes, which I'm not very good, and you can yell at me whatever you want, but I'll tell you when your time's up.
Thanks. Okay, is that on? Great. So thank you for the introduction, Hassan, and thank you for inviting me to this conference. It's been a great conference. I've been very impressed with all the speakers that have gone before me. I must say it's been intimidating, though, to have to follow this great lineup. So I hope you'll bear with me, particularly the last panel of the day. I apologize, I don't have a PowerPoint, and neither do my co-panelists. So hopefully we won't have to click, so maybe it'll go a little faster. I'm going to talk today about the same sort of theme that we've been talking about precarious employment. I think it really follows from Faye's presentation right before the break. But I'm going to take a little bit of a different approach. I'm going to talk about it in the context of charter litigation. What we've heard this morning and this afternoon is that collective bargaining, as it's structured under the Wagner Act model, is generally only available to certain groups of employees, and those that are structurally positioned as individuals who have a strong attachment to typically a larger employer. And that it's not working for the precariously employed. And I think we need to have governments protect core labor rights for all employees and not just those that fit that paradigm from the 1940s and through the 70s. And we, in particular, need to ensure that our most marginalized employees can organize. So when I did my PhD 20 years ago, my subject matter of that was sectoral bargaining. And I talked about a lot of the difficulties that were discussed in the previous panel. And then I didn't think about it for quite a long time, been involved in other things. I mean, it's always been in the back of my mind, but I haven't been involved in it. But it's percolated up again and sort of even hit mainstream media. And what I was kind of surprised about 20 years later is that really nothing has changed. And, but the one thing I think that has changed in this time is that collective bargaining and the right to strike are now constitutional rights. And so I think we need to think about how that fits in with all of these workers that are facing a system in which they cannot organize. And we are talking about the most economically exploited. A number of different governments have done workplace reviews, the most recent being the Ontario Changing Workplaces Review. And still we don't have a recommendation to have broader base bargaining for these vulnerable employees. And I don't want to get into all the definitions. We've gone over that a lot today. So I'm just going to assume that those definitions are what I'm talking about. I'm talking about the low-wage sector in particular. But I will say that I understand that a lot of good changes are being made. And that will come out of the Ontario review. But I do agree with what Faye said before, that tinkering with this decentralized, sort of firm-based Wagner Act model is not sufficient. It's a Band-Aid approach at most. And it's true that broader-based bargaining is not new. It is in other sectors, the construction industry, it's in health, it's in education. In all of those areas, at least in BC, that was pushed by the employer community. So they get it when the employers push for it. So I think we need to be pushing for it from the other side. And I know a lot of you are on the employer side here. I assume you're at this conference because you care about these issues too. So I hope there's not such resistance to it, particularly for these vulnerable employees. But I will say that we've got a couple of things that we can use in terms of litigation. First, we've got international law, which our talk about labor rights as core, fundamental human rights, and that they should be enforced as such. And we have the Supreme Court of Canada, which is increasingly using these international instruments as an interpretive aid in charter cases, especially in Dunmore and Health Services, it was used. We have a new development that has also been mentioned today, that Convention 98 has finally been ratified by Canada. And I think that this is important. It was ratified in June because the convention explicitly recognizes core labor rights as human rights. Some of the other conventions do that too. But what I think is really important, and what Hassan mentioned at lunch, and Kevin Banks has also written about, is that it requires states to take positive steps to protect all associational rights and to actively promote collective bargaining. So Canada has now agreed to this, and I think it's time that we insist that the governments do something about this. So I may be naive to think that a constitutional challenge will work in this case, but I'm going to put it forward as a possible solution to all of the problems. I'm not saying it will remedy all of the problems we've been talking about, but as one sort of way to challenge what has been going on. And I think if we ground it in freedom of association as a fundamental human right, we can tackle the real barriers that the current legislative frameworks creates for those in the fissured workplace and for the precariously employed. And Mounted Police had said that collective bargaining is necessary to rectify power imbalances in the workplace. And where could this be more compelling than with respect to the precarious employees? So the issue is, how would we frame this legal challenge? And I think it would need to be framed as a positive rights claim. And I know that that's a bit controversial for the lawyers in the room. And that's really saying, what affirmative obligations should the courts place on governments to protect these employees? The Charter generally protects negative rights, meaning that they prohibit governments from interfering in the lives of citizens or requiring the state to refrain from infringing upon constitutional rights and freedoms. Positive rights, in contrast, are conceptualized as creating entitlements that governments must provide to ensure the exercise of a constitutional right. And many academics and legal scholars have talked about the difference between positive and negatives and whether they are something we should be using. And this discourse is animated by the highly contested issue of judicial activism. So that, of course, is an emotion. Some people have a very emotional response to that. Those who resist positive rights talk about the lack of institutional competence on the part of the judiciary, that judges shouldn't be getting involved in social policy issues, especially in cases where we're talking about the allocation of scarce resources. And they say it's not the proper role of the judiciary to tell governments to change legislation. And on the other side of the debate, we have those who say, that are in favor of positive rights, saying that the framers of the Charter made a deliberate choice to limit parliamentary supremacy. And as Justice Iacobucci said in Verend, the courts have assumed new powers of judicial review through the deliberate choice of the provincial and federal legislature with the passage of the Charter. Those who advocate for positive rights also talk about the purpose of interpretation of the Charter and that you need to have a broad scope for rights. And Justice Arbour in Gosselin, in dissent, really talked about that approach to positive rights. Now, I will say, I think there is a legitimate concern that the judiciary overstepping its institutional role, and we wouldn't want to have necessarily be pushing for positive rights in every case. But I do think that in a constitutional democracy, we have to acknowledge that constitutional adjudication does involve judicial weighing and sometimes making policy decisions, including budgetary decisions. A lot of the cases have those implications, even the negative rights cases. So in terms of a successful positive rights claim, it doesn't mean that judges should become involved in legislative drafting, but that they should define the need to protect the right or freedom in general terms and then leave it up to the legislature or parliament to draft the legislation. And this is usually accomplished by issuing a declaration of invalidity for a period of time, as we've done in a number of the cases that we've been involved in as the labor movement in Dunmore, Health Services, Mounted Police. And those cases are all Section 2D cases where the Supreme Court of Canada has recognized where circumstances warranted that positive rights play a role, and they've not shied away from imposing these obligations on governments. And I think that this is best demonstrated in the Dunmore case, where farm workers were specifically excluded from the statutory scheme that was available to most other workers in the province. And the court said that although the state is not ordinarily required to take affirmative steps to provide protection, it recognized that by excluding these agricultural workers from the protective legislative scheme, it contributed substantially to a violation of freedom of association. and that in these circumstances, the Charter may impose a positive obligation on the state to extend the protection to the unprotected groups. So the court did helpfully set out the test for when it should get involved in under-inclusive legislation, or when it would be a proper challenge. And it said first that claims must be grounded in a fundamental charter right as opposed to a statutory right. Second, the claimant has the evidentiary burden to demonstrate that the exclusions result in substantial interference, here with collective bargaining. And third, that it must be in circumstances where the state can be held accountable for the inability of the claimants to exercise their fundamental freedom. And that one may be what is perhaps more difficult to prove. But in mounted police, we had another case similar to Dunmore under inclusion, and I see I'm already been told I'm out of time, so I'm not going to talk about these cases. I've had a little summary of each one. But we have a number of positive rights cases that the Supreme Court of Canada has been willing to use that analysis. Mounted police was the 2D case. There's also a number of cases under Sections 15 and Section 7 of the Charter. Schachter in 1992 was one of those cases. Eldridge in 1997. Gosselin, which I've already mentioned, that case was Section 7 and 15 claims. The court dismissed those claims, but Justice Arbour had a fantastic, extraordinary, but fantastic dissent on these issues, and I do encourage you to look at that. But she basically said that Section 7 can impose a duty on the state to act, and that a state's decision to exercise its legislative choice in a non-inclusive manner is a state action. So in the past, it's always been kind of assumed that it's a non-action. It's not something that the courts should become involved in. She also said that the concept of deprivation in Section 7 is sufficiently broad to encompass non-action on the part of governments, and that courts then need to fill that void. We also have the Insight case coming out of Vancouver, the injection site that is also, the court directed the minister to grant an exemption under the Controlled Drugs and Substances Act. So there are a number of cases, and that's just scratching the surface, in which positive rights have been enforced. So I think the question in the present context is, to what extent is the state required to legislate to ensure that collective bargaining is accessible to the precariously employed? And it's a bit complicated because although there are some exclusions in the legislation to agricultural workers, domestic workers, most precariously employed individuals are not specifically excluded. But as we've heard, the structure of the legislation makes it virtually impossible for them to organize. And so I think as a class, we could bring a charter case to challenge the government in action in not fixing that legislation. And I would assume that we would have done it through this labor law reform, but none of the labor law reforms that I'm aware of are pushing for broader-based bargaining for this marginalized group, the ones who need it most. So I don't think, so I think we skip over all of that. I think we need to look at least have a serious debate about how we eliminate these structural barriers in light of the constitutional right to collective bargaining. And we'll need to focus on the state omission rather than government interference. And I do think that the precariously employed meet the Dunmore test, that it's grounded in a fundamental charter freedom. The result is substantial interference with the freedom of association, and the state is accountable. because the legislation is under-inclusive. There could also be a Section 15 argument that precariously employed workers are entitled to the equal benefit of the law. And that analysis, the equality-based analysis, was used in Eldridge, Schachter, and Brand. So I think that's a first step. I think we should be seriously considering that. That's not going to solve the problem. To get governments to pass the legislation, they'll have to figure out the models, what have you, and then it'll be up to the workers and the unions to do the hard work. Thank you very much for your time.
Does that work? Yes? Hi, everyone. First, thanks to the organizers for having me here. I should apologize to the people whose presentations I missed this morning. What happened was I initially had planned a very different talk that was not entirely responsive to the nature of the conference. It was very abstract and philosophical and ultimately probably unhelpful. So I realized that at about 1:30 in the morning and decided to redo my presentation. So I'm climbing without a harness here, so bear with me. I want to just talk about, from a relatively high level, about what the court has been doing through Section 2D, and Diane's presentation was fantastic and sort of a good lead-in to me saying something like the opposite of what she said. First, I want to start out by saying we hear a lot about the court being activist and you know, taking steps that it shouldn't take. And in one sense, the court has been activist on a case-by-case basis, if you just mean that they've been active and they've decided cases. But on another level, they've been very deferential in the sense that what they've been doing is essentially deferring to this broad statutory compromise that we've had for the past 100 years. And you see when you go through, I mean, I know when you read the cases, they say, we're not constitutionalizing a particular form of collective bargaining. They say that every time. But it's conspicuous that every case, they add a new part of the sort of Labor Relations Act as they go through, and they look to Labor Board case law when they're defining what it means to have a meaningful right to collectively bargain. And so I think they've been doing this since basically Dunmore. And so that's what I want to talk about a bit. I mean, I think that a lot of people have covered the issues with that and the issues with the Wagner Act model and its availability and its unavailability to so many people. So I'll end my presentation just on whether any of this matters, which I have some doubts about, but in the sense of the Supreme Court's decision-making processes and whether that will actually achieve what there seems to be a consensus needs to be done to help people who don't have access to the Wagner Act model. So very briefly, there's a US academic named Christian Rogers who wrote a paper recently called The Three Models of Freedom of Association, and he goes through these. And I'll talk about two of them because they have purchase here in Canada. One is the civil libertarian model, is what he calls it. And that's just your basic core freedom, your negative rights, your ability to do together what you can do alone. And that's what the court emphasized in the original trilogy. They gave it a rather cramped application. I think that there's a broader, more robust way to look at that freedom. But the problem with it is that, I think I was at a conference a few years back when I was in law school, and I think it was Paul Cavalluzzo who said, you know, that freedom and a quarter will get you a cup of coffee. And for a lot of precarious workers, for a lot of people in that circumstance, that's not what they need. They don't need that core freedom. They want to still have that, you know, that's still important to them as Canadians and everyone else, but they need stronger, more robust statutory protections. But it is still an important part of the picture, I think, the civil libertarian component. And it's been important in cases, in a lot of the freedom of expression cases, the cases like Kmart and Pepsi Cola, and more recently the UFCW case, where due to this statutory compromise or to certain restrictive, deviant common law notions, union workers weren't able to exercise the same fundamental freedoms that everyone else had and that everyone else had access to, which was just our ability to go out and protest and picket and do whatever they want. They were under unique restrictions in that regard, and the court swept them away, and I think that's important. But as I said, it's not everything, and it's not sufficiently meaningful. So the second conception is the social democratic conception. This is what Professor Rogers calls it. And this is what he talks about, the Wagner Act model, and how this is the more robust, powerful collection of collective rights that makes that basic minimum freedom meaningful and effective and powerful for people who have access to it. And the big problem, as a number of people have talked about already, is that it is only available to a smaller and smaller subset of workers. I don't need to go through that, because I think a number of people have covered it. But what the court's been doing, I think, and I think it is tied to their view of their own role, their own institutional capacity, is that when they've been doing these Section 2D cases, they talk in these big, grand terms of a meaningful right to collective bargaining. And they talk about it as a fundamental freedom available to Canadians, but it's not, because it relies on this statutory superstructure of rights that functions, well sometimes and not well other times, and is completely unavailable other times. And I think it's a very strange conception of a fundamental freedom that is only available to a small subset of Canadians. It's a strange notion. So the question then becomes, well, what can the Supreme Court of Canada do about this, if anything? And I think Diane did a good job of giving the optimist account, that there is something that the court can do to improve the lot of a lot of Canadian workers who are left out. And I think that they can and are willing to do that for those types of under-inclusive statutory exclusion cases. So Dunmore is a great example, because what they could do is they could say, look, you guys, you can go redraft this if you want, but if you don't, we're striking out this exclusion, which means that you're just into the general collective bargaining system that everyone else has. And that would be the outcome if the legislature did nothing. And so but the problem, of course, is that if that, statutory superstructure of rights and obligations and the entire system is itself not working well, the court doesn't really have the ability, and I don't think the inclination to fix it. Like I said, they can tinker, they can slash, they can make sure people aren't excluded from it, but they can't or won't do anything broader than that. I suppose they could, make an order, these people, even though they're treated the same way as everyone else, have, I guess you could say, formal access to this system. They don't have real practical access, but to the extent that that requires this big visionary thinking, which I think a lot of people have concluded that it does, there's maybe not a lot that the court can do. I'll just talk briefly about Saskatchewan Federation of Labour, because I think that there's an important part of that case that people tend to ignore when we talk about the right to strike that was given to the people who were excluded, again, from the statute. But there was another really important part of that case, which was the changes that were made to the certification procedures and the decertification procedures. And I think a lot of people know that can have a lot more of a real day-to-day impact on people's ability to access this huge statutory protection. Is that, it's the door that gets you to where you want to be to have this full substantive protection. And the court dealt with that in a paragraph, I think. They just swiped away that claim. They said, leave it to the legislature, they can sort it out. But even minor changes to that can have a real effect on how many people actually have access to this huge superstructure of rights that the court has been saying are constitutionally protected for everyone, but in reality are not. So I sort of had this as the optimist says this and the pessimist says this. I'll go back to the optimist just for a moment to talk about Professor Dury's paper he wrote, some of you may have read, on graduated freedom of association, it's called. And so what he's done is look at it and say, okay, look, this Wagner Act model, that works for some people and great, that should be protected. But we also need to think about these other core aspects of collective association, of freedom of association that aren't the full Wagner Act model, but that are a way that might help people organize and work together and engage in various forms of collective action that are not sort of the full Cadillac type approach, but are still a meaningful way to engage in that type of action. And it has to depend on rights and freedoms that can be created that don't depend on this massive structure, on the labor boards, on the certification, on this, but are more narrow. They're not as powerful, but they're still worthwhile. So I would recommend that paper to you. Let's see what else. The pessimist, I've already sort of given a lead into the pessimist. There's a couple other potential problems. The one is the idea that some of you might have heard of charter proofing, which is where it's I guess a political scientist's idea where once the Supreme Court says things like in Saskatchewan Federation of Labor in one paragraph that, okay, that scheme is fine, then legislatures or the public gets it into their mind that this is your entitlement. This is what you get. And the Supreme Court has said this is what you get. And so that's fine. And so I think that there's some risk in that happening. I don't know how real that risk is on the ground, but I mentioned that. The final risk is where the court conceives of freedom of association in these terms, in these sort of Wagner Act model terms, and is unwilling to deviate from that. So I'll just give you one example, is that there may be forms of collective action, collective representation that don't depend on a completely antagonistic relationship between employers and employees and associations. That it would be a shame for people who don't have access to the full Wagner Act model protections and don't see that on the horizon to also lose that opportunity, and Professor Dury talks about that as well. So I think that maybe that's where I'll end. I had a few other comments, but I think people have covered them, fortunately, so I'll just adopt my friend's comments on that. Thanks very much.
Hi, everyone. I'm going to try and sort of cut a path between the pessimist and the optimist. And I want to talk specifically, and this actually, it flows very nicely. I'm going to talk specifically about remedies in charter litigation, and particularly under freedom of association. Because I think one thing that we've talked about this a lot on this panel, we've talked about it a lot today, and we've talked about it a lot in the past few years in the Labour bar in Canada, especially since the new trilogy in 2015. It's very clear now that protection for freedom of association includes pretty robust rights to collective bargaining, now to a right to strike for workers. It's also very clear that at least some Canadian courts, including the Supreme Court of Canada, are quite happy to find that a violation of these constitutional protections has occurred. But I think that what's really interesting now, and what's not clear, is what happens after that. What happens after a violation has been found? And specifically, how should litigants and how should the courts and potentially administrative decision makers be thinking about how you remedy violations of the protection for freedom of association? Because I think that this is sort of wide open territory right now. I don't think anyone has really thought about it, or at least very few people have begun to think about it. But I think it's very important. You know, one theme we've talked about a lot today generally is effective access to freedom of association. And it seems to me that the remedy stage of constitutional litigation in the labor context is probably where you're going to instantiate effective access to freedom of association. So what I want to do is talk very briefly about a couple cases, recent cases, and the remedies that were issued by the courts in those cases to illustrate this sort of lack of clarity of the problem that I'm suggesting exists. Then I'm going to talk about, very briefly, some developments on the international level, which thankfully Brian already covered, saving me some time this morning. And then, briefly going to comment on what may be coming down the pipe, or at least what should be coming down the pipe. So a couple examples from the case law to elaborate on this problem we have with remedy right now. First case I want to talk about is a well-known case, Canadian Union of Postal Workers, Canada. This was CUPW's charter challenge to the back to work legislation that the Harper government brought in 2011. Complicated case. In short, the union claimed successfully that the back to work legislation that was passed violated their rights to freedom of association, including the rights to collective bargaining and right to strike. They asked for two remedies. They asked for one, a declaration under Section 52 of the Charter that the back to work legislation be struck down. They also asked for a second remedy, ultimately, which was a request for damages under Section 24 sub 1 of the Charter. Okay? The union was, I would say, almost entirely successful on the merits of its case. The remedy stage is a bit of a different story. What happened at remedy was really, first of all, Justice Firestone of the Ontario Superior Court of Justice found that in this case, it's an extremely high standard, an extremely high threshold to grant charter damages. And in fact, you need to have essentially bad faith conduct almost on the part of government before damages are going to become available. Second important point is that Justice Firestone noted, and this again is relying on an extensive body of case law, that you typically will not be able to get both a remedy under Section 52, a declaration of invalidity, and a remedy under Section 24 sub 1 of the Charter, which is very important because 24 sub 1 is sort of your open door. It allows a court to grant any remedy that is appropriate and just in the circumstances. But the case law says you usually can't get that if we're granting a declaration of invalidity. And on the facts of this case, where the union was successful, Justice Firestone said, no, the government's conduct here did not warrant charter damages. And also, this is not one of those unusual cases where a remedy under Section 24 sub 1 is appropriate. The union is entitled, however, to its retroactive declaration of invalidity. But again, the back to work legislation had in some ways, the union would say at least, it had already done its job. Okay, but it gets a bit more complicated here. There was a question that was raised because this is a case involving CUPW, Canada Post, the Government of Canada. These parties have a lot of litigation going on at any given time, grievance arbitrations, labor board proceedings, etc. what did the retroactive declaration of invalidity mean for the collective agreement that had been brought back into force by the Back to Work legislation? This was an issue in other proceedings between the parties. So parties ended up back before Justice Firestone a bit later because the union was asking the judge to confirm that the collective agreement that had been brought back into force by the Back to Work legislation remained in force. And they asked for a declaration under Section 24 sub 1 of the Charter to this effect. Justice Firestone said no, ultimately. I'm not going to do that. And there were a variety of reasons why, including an agreement that had been reached between the parties at the merit stage. But he also looked at the nature of his role as a judge considering a constitutional case. He said, the decision has been issued. I'm functus officio, which means, basically I don't have jurisdiction to do anything anymore. And that was that. That's that case. So we're left with a situation where the union has won on the merits, but it was not successful, I think, on the remedy stage, or at least it didn't achieve everything that it wanted. Another good example of this is that can be found in Saskatchewan Federation of Labour, which has been referred to before today. This is the case in which the Supreme Court struck down Saskatchewan's essential services legislation based on the restrictions that it imposed on designated workers without providing some sort of independent third-party scheme by which those designations could be challenged. Again, in this case, the workers at the merit stage, the unions were, I would say, entirely successful in many ways, although Ben's pointed out the important point about the changes to the decertification and certification provisions in the legislation. But on essential services, at least, they were successful. But then they end up back before the trial judge to adjudicate the union's claim for damages under Section 24 sub 1 of the Charter. And despite, again, the union's success on the merits, the trial judge, and this is in 2016, conducts a very similar analysis to Justice Firestone in the Cup W case and says the conduct at issue here simply does not meet the very high standard required to order charter damages. And again, it goes back to this principle that a declaration of invalidity under Section 52 of the Charter is appropriate. And it's only in very rare cases that a union is going to be entitled to anything more, or any litigant is going to be entitled to anything more under Section 24 sub 1. So again, entirely successful in many ways at the merits stage, not so successful on remedy. There are some exceptions to this, and I told Diane I was going to talk about one of her cases, which is the more recent BCTF case that was decided late last year by the Supreme Court in a very brief oral ruling. What's really interesting about that case is the dissenting justice at the Court of Appeal, Justice Donald, whose approach was upheld ultimately by the Supreme Court, did make an order under Section 24 sub 1 reinstating specific collective agreement terms that he found, and he found that this was necessary essentially to provide an appropriate remedy to the union in this case. But at the same time, Justice Donald did not give the union everything it wanted, no damages under Section 24 sub 1 of the Charter, and there were also changes to the declaration of invalidity that had been ordered by the trial judge. So again, the story I'm trying to tell here I think is pretty clear. We have constitutional rights. We have judges finding that constitutional violations have occurred in the labor context. But then you get to the remedy stage, and we're trying to fit labor relations situations on the ground, labor disputes, into a quite rigid constitutional remedy framework. And specifically, where are we left? Where does this leave us? So I would say, and this is generally speaking, a successful litigant can count on Section 52 declaration that legislation that's unconstitutional is invalid. Great. And that can be very important. I'm not trying to diminish that. It can vindicate workers' rights. It has important precedential effect in many cases. And also when you're dealing with legislation that will go forward, like essential services legislation that needs to be recreated, again, it's a very important remedy. But then we have Section 24 sub 1, which is really where the broad action can happen. But judges are not really willing at this stage to think about how it can be used. And indeed, the constitutional case law on Section 24 sub 1 supports a really rigid approach to granting remedies. So we've got a very blunt tool. We've got Section 52 declarations, may or may not be helpful, can cause trouble. We've got judges who are not retaining jurisdiction over cases. And we've got very high standards for the granting of other remedies. So where does that leave us? Where should we go from here? Well, Diane talked a little bit about, and others have talked a little bit about international labor law. And I think a lot of us, in particular on the management side, have been extremely skeptical, and Ben's written about this, and so has Brian Langell, about the Supreme Court's use of international labor law. But what I would suggest is when it comes to remedy, some very interesting things are happening at the international level that may be able to provide at least some guidance to Canadian courts, Canadian administrative decision makers about what's next, what's important. Brian talked a lot about the UN guiding principles earlier today. What's really interesting about the UN guiding principles is the focus on how do we grant effective remedies? How do we create systems that respect and implement freedom of association where a violation has occurred? Well, in 2 weeks, there is a large conference going on at the UN Forum on Business and Human Rights. Actually, I was just looking at the sort of flyer. There's about 2 pages of bullet points talking about how the topics that will be considered include things like, how do investor rights regimes implicate freedom of association? What are effective grievance mechanisms? How do you create effective remedy in situations where the parties will have an ongoing relationship following a dispute? These are issues that I think the international community, including the international employer community, are thinking quite carefully about now. And I guess my suggestion here is not that everything that is coming out of that process is valuable or correct, but it is an exercise that Canadian decision makers, Canadian judges, may wish to look to when they're trying to figure out how are we going to deal with remedies in the constitutional litigation scenario. I think I would just end by saying, and this is sort of from a management side perspective, I don't think that there is any benefit to anyone, workers or employers, when there is a lack of clarity as to how a remedy that is issued where a charter violation has been found. I don't think that benefits anyone. So this is an exercise, I think, in which both parties, employers, unions, worker representatives, and of course the state should play an active role in thinking about how you create meaningful remedies where a charter violation has occurred that provide some basis for an effective ongoing relationship. And I think I'll leave it at that.
Thank all our 3 panelists, of course, for their perspective. I'm sure there are many questions that you, the audience. Michael?
Thank you for that. Thank you for all your presentations. I wonder if I could ask you a question that you're all invited to speak to. And it has to do with Section 2B, which is the freedom of association, the cornerstone of the charter. I was, first of all, as some of you have alluded to, it took 20 years for the court after 1987 to begin to reverse itself. One would say 14 years, but by really 20 years, DC help begin to reverse itself and give some substantial meaning to Section 2B. But what we have now is Section 2B. Still, to find a breach of that, you have to find a substantive breach of it, which is a much higher burden on the plaintiff than for either Section 2A you still haven't, in terms of remedies, they still haven't thought through how you want granting consent around these provisions, even when they're written on the Postal.
I'll just make a quick comment on the substantial interference. I think it is wrong that they added that test. It conflates what should really be the justification in Section 1 is now been put into the right itself at the outset. And that said, I think some people would argue, well, they gave the example of parking spaces or something, or cafeteria, that maybe it didn't mean that much. But it really depends on the court you're in front of. They have that test, and they're allowed to now read justifications into the as a threshold matter at the right stage. And you're right. There is no explanation for that, and it is a higher burden for any claimant.
I think it's a good point. It's one Professor Langell likes to talk about, and he's quite concerned with the fact that, and I think the way that he would describe it is the court, because the court has been looking at a meaningful right to collective bargaining as part of this entire Wagner Act model package, and not conceiving of it as just this basic core freedom that we all have to do with one another or alone, which is to sort of bargain with our employer, whether that's effective or not. We have that core civil liberty. And I think that he would say that by viewing it as this sort of broader substantive right to this process, rather than just, it's, the unions in that case are just trying to do what anyone could conceivably do alone, just exercise their legal freedom to engage in those types of conversations. So if what you're talking about is a BC Health type case where they just said, nope, can't bargain over this, can't bargain over that, can't bargain over that, he would just see that as your basic freedom is being trampled on because you're doing it collectively through a union. But if what you're saying is that you haven't been given sufficient collective protections, rights, and things like that, then some higher standard seems appropriate.
I have a very brief comment on this. I think, to put it bluntly, I think that this is sort of a good, a doctrinal way of courts sort of trying to keep that traditional separation between the court and the labor board. It's almost like the substantial interference test is a way of saying, I'm not going to look, I'm not going to look, I'm looking, I'm not going to look, I'm not going to look. And, it seemed to me always to be a way for the court to sort of try and keep some distance from the facts in a bargaining dispute. But then to say, well, if it gets this bad, we're going to have to intervene. Of course, I think, we could probably talk for a couple days about the problems, the pros and cons of a situation in which a court, especially one that is not staffed with labor relations experts or human rights experts even, is looking and trying to assess the sort of narrative, the sequence of a bargaining dispute. And I think that, in short, substantial interference is their doctrinal way of trying to do this.
I just have a question for Chris, Brandon. I just wonder what the justification is for, if you get a declaration of invalidity, why the court system don't therefore participate in invalidity?
So, very good question, and I think the short answer is, it's a jurisprudential one. Well, and there's a couple issues here. The basic issue is that the courts have interpreted Section 52 declarations of invalidity as applying only to situations in which government passes an unconstitutional law. Okay, so only when a piece of legislation is passed does Section 52 come into play. In contrast, Section 24 sub 1 is intended to deal with unconstitutional acts by government. So, if government is acting as an employer and government representatives bargain in bad faith or commit some, and it's not just the collective bargaining context, of course, this is any context where government is acting and subject to the Charter. 24 sub 1 is what you use to remedy a situation in which it's not legislation that's at issue, it's government action. Of course, when you get into the collective bargaining context, arguably, and I think what a lot of unions would say, both is happening. And the case law here, I think, tries to say that in situations where both are actually at issue and a declaration of invalidity can't give meaningful relief, those are the types of unusual cases where 24 sub 1 can come into play. But what's interesting to me and is always to think about how would a labor board handle this, right? And I think part of my criticism of the court's approach would be that if the court is going to get into the business of trying to adjudicate labor disputes, you need to think about what actually works. And I think labor boards in Canada generally do quite a good job of trying to match the remedy, and often very creative remedies, to whatever type of misconduct or situation has developed at the bargaining table. So, labor boards issue a wide range of orders, remedies. Courts do not. And, I think that this, again, we're trying to fit labor disputes into a sort of very rigid constitutional box and it was not designed to deal with labor disputes.
Becky?
Well, Diane actually is probably a better place to speak to that, given the BCTF's experience.
Yeah, we had that very situation. When we were in front of the trial judge, she gave us both a Section 52 declaration, but she was also very unhappy with what the government had done, and so she went further and imposed the collective agreement language back to 2002 when it had first been eliminated. And in addition to that, under Section 24, and she said that was a matter of law I don't have time to explain why, but that was still sort of part of the Section 52 remedy. But then she went further and said that you get a Section 24(1) remedy because the government had basically acted in bad faith because they'd been told we had two separate cases. We were told that the legislation was unconstitutional, and in 2011, and then the Fraser case had come out, and so the government decided not to appeal and decided to consult with the union instead. So they consulted, and then what they did is they repealed the legislation after the consultations failed, and then after they finished, they repealed the legislation, and in the same piece of legislation, they reinserted the same clauses. So they repealed them because they were dealing with the first decision, and then they replaced them because they'd consulted now in good faith, and so now they could do this. So then we were back in front of her, and she was very upset with that behavior. And as a result, she awarded $2 million in damages for that. When we got up in front of the Court of Appeal, well, we lost in the Court of Appeal, but the dissent didn't give us quite as rich a remedy, but did say, yes, you get your clauses going forward, but I'm not going to go so far as to give that Section 24 remedy. So we lost that $2 million, and that's what ultimately the Supreme Court of Canada upheld. But I must say, when we were in front of the Supreme Court of Canada, one of the first questions as Chief Justice asked was, what do you want for remedy? And I must say, my co-counsel was so stunned. He was like, oh, I'll let my co-counsel deal with that. He wasn't expecting it, and and the reason he didn't want to answer it was because it was wound up in what we had done in collective bargaining in the interim. But in any event, we didn't need to have, because we had settled out the issue, we didn't need to have the clauses reinstated back to 2002, and so we were only asking them on a go-forward basis. And so then the court was happy with that, and then they reinstituted Justice Donald's decision. I don't know what they would have done if we'd said we wanted those clauses back to 2002. I have no idea what they would have done with that.
Kevin?
So if there is a positive right to protection of the right to government collective, does it go beyond unfair labor practice protections, organizing, bargaining collective strike? Would that be enough for guys to right to collective? This is a question for all of you. If you were to concede that there is a positive right, what would you do?
Well, I was thinking that they need to have some sort of broader-based model, that because they are being excluded because we don't have that. I was saying that the court would likely give a period of time for governments to determine what that would look like. But I guess that's fairly prescriptive and goes beyond the unfair labor practices. But to make collective bargaining meaningful, you've got to make the structure meaningful. But I do think it begs the question that Ben was talking about whether we're constitutionalizing certain aspects of the Wagner Act. And I don't think it's doing that. I just think that a lot of the provisions in the Wagner Act are actually necessary to make collective bargaining meaningful. But I think they would have to leave it up to the legislatures to try to come up with some sort of model that would work. And I don't think the court is going to get involved in saying what that exactly would look like. I would be very surprised if they would go that far.
Yeah, I mean, it's difficult when we're talking about these concepts of positive and negative rights, and particularly in the labor relations context, it's hard to know exactly what we're talking about. I mean, in Dunmore, they were able to just strike down the exclusion and leave it up to the government if they wanted to try to make a constitutional statute other than the one they already had. So in a sense, that was giving farm workers a positive right to that unfair labor practice protection. And then in Fraser, I think, as I understand them, they upheld that statute, but only on the basis that it provided farm workers with an opportunity to make collective representations in good faith. And as I understand that case, if it didn't provide at least that, then it would have been unconstitutional, and you would have that positive right to that type of protection. And so I think that what has been so problematic in the labor relations sphere is that because these other fundamental freedoms are protected almost exclusively through striking down restrictions on the exercise of your freedom to speak or to say this or to do this or to practice this, religious practice. Those are easy cases for courts because they can just say, that's gone, that restriction's gone in the criminal code or wherever it is. But in the labor relations context, as we've been talking about, that bare freedom to associate, in some cases, like, and Mr. Sims was talking about this, in some cases that bare freedom can be hugely important and powerful when you're the body that is powerful, when you're the union that has that type of control. But in so many cases, there isn't, they don't have that power, and so their freedom, they have their freedom, but it's meaningless without this further positive protections, and we've come to accept that in the Wagner Act model. And the courts come to accept it as something that sort of inheres in this idea of freedom of association, but it's so different from the way we approach all of the other fundamental freedoms that it creates these very confusing and troubling issues about what the court is able to do, how far they're able to go, what their sort of remedial powers are, because the court can order the legislature to say, you know, these people who are covered by the Wagner Act model aren't able to organize, do something about it. But then it's up to the legislature, and the legislature will come back and probably do the bare minimum, the way they did after Dunmore with Fraser. They did what they thought was the least amount they could do. So it just creates all of these issues.
Yeah, I think that this is a problem the court is already running into, and I think we need to keep in mind, for example, in Mounted Police Association, the court did go further and say, you know, a constitutionally compliant bargaining system is going to have certain key features, including employee choice and independence. And you know, you read the majority's decision in MPAO. This principle of employee choice is, they frame it as absolutely fundamental to the protection for freedom of association. And I see that Bernie and Craig and John Craig are all sort of, their ears are perking up here because they have a case that deals with this issue. And you know, and the issue, and we don't have time to get into the facts, it probably wouldn't be appropriate to get into the facts, but it's interesting how when the court does start articulating principles, and we can argue about how important they are to freedom of association, but when the court articulates a specific principle like employee choice as part of a constitutionally compliant scheme, what happens when that principle pops up in a different fact scenario, and you know, maybe it doesn't weigh against or weigh in favor of workers' rights? And I can tell you, several of us were at that hearing at MPAO, and I think one of the reasons that this issue came up so forcefully, and there's comments about designated bargaining in the decision. Well, counsel for the Attorney General in that case, after employee choice began to be talked about by the bench, counsel for the Attorney General got up and said, I just want to remind the bench that the entire Ontario public school system is based on no employee choice. There is a designated union who bargains on behalf, designated by legislation. That was the only time that designated bargaining came up at all in the written submissions or in argument. And it worked its way into the decision. So it's interesting. It's a good example. And you know, the board and other decision makers are grappling with employee choice right now. The question becomes, though, how, when a court is articulating what's important in freedom of association in practice, how does it articulate principles that can have sort of a consistent meaning through very different fact situations, some of which might involve organizing in the public sector, some of which might involve organizing in the private sector and precarious workers. Other situations might involve collective bargaining disputes. What does a principle like independence mean? What does a principle like employee choice mean? I don't know, but the Supreme Court's talked about them a lot now in Mounted Police Association, so they must mean something.
So one quick point on this particular case, and subsequently the legislature response to the original draft of the legislation to give the RCMP workers this fundamental ruling was so flawed that the Senate had to amend the bill to actually make it amenable to what the courts were intended. And actually, if you go back and read to the amendments that came from the Senate, they were just bold and explicit. That's how the legislature, the House that is, got the legislation so wrong. Subsequently, when the Senate, all of its amendments did go back into the House for, which is an unusual thing, the House never takes advice from the Senate. In this particular case, they did, adopted all of the Senate's recommendation to actually make the bill consistent with the ruling of the Supreme Court, because the House had said that these workers don't even have the right to go on strike, how they would be treated in that regard. But what was quite fascinating is that the tug of war that went on, and finally the the minister responsible acknowledged that there was major flaw in how they had drafted the legislation, until the second chamber did actually correct many of the flaws that subsequently became, which is now the law of the land. Again, quite often the courts say one thing and then the legislators say, well, we can fix that problem, and here's a solution. And quite often the solution is not what was perceived to be the intention of the courts in the first place. And in this particular case, I have to say the Senate did get it right versus the House. It's an unusual situation, but it's maybe an anomaly in the context of the legislature and its role, where we do have a second chamber to actually second guess the House whether they made the right decision or not. I think there's time for one more before we adjourn. No? Over to Michael.
First of all, let me thank the panel for such a great job this afternoon. Thank you, Hassan, for sharing this. I'm going to be very brief. I want to be able to thank all of the speakers and panelists and chairs today. I think it was a wonderful day of intellectual thought and discussion on such an important topic. I want to thank the audience for coming here and being so patient and picking a room that was 10 degrees warmer than the hallway outside. Thank you for that. Brian Burkett and John Craig, if I can thank you, and have your corporate entity here, for Fasken Martineau, for another wonderfully paired conference with Western Law. I'm very grateful, and the school is very grateful for your continued support for this. There are some unsung heroes I just want to be able to comment on and give my thanks. Amelia Greco, Susanna Ayers, Corey Meingarten, and Adeline Saunders from the staff of the law school have been instrumental in making sure you're all registered, that rooms were booked, that the food was delivered, that the tables were set up. And I also want to thank, and I don't have their names, and this may be a backdrop to the kind of issues we're talking about today, but certainly to the banquet workers that we've dealt with and the cleaning staff as well. I want to thank them all. So we can all join me for thanking